2024-09-07, introduced by Commissioner Gillum.
To the Honorable Mayor, Mark DeWitt, Chairman, and members of the Hawkins County Board of Commission in regular session, met this 23rd day of September 2024. Resolution in reference authorizing Hawkins County to allow the Terry Law Firm to enter into litigation on its behalf against HolstonConnect in reference to franchise fees not being paid. Whereas HolstonConnect operates a high-speed fiber service which provides internet, telephone, and television to its subscribers in Hawkins County, and whereas video service providers are required to pay a 5% of gross revenues franchise fee to the municipalities and counties where they operate, and whereas HolstonConnect has thus far refused to pay the franchise fee, and because of this, Hawkins County has lost significant amounts of revenue, and whereas the Terry Law Firm from Morristown, Tennessee is willing to represent Hawkins County in a contingency fee arrangement where Hawkins County would not pay any money unless the Terry Law Firm is successful in the litigation, and whereas, as detailed in the attached letter and contract, should the litigation be successful, Hawkins County would pay 25% of the total recovery plus expenses. The expenses would be divided pro rata with the town of Bulls Gap and any other party represented by the Terry Law Firm. And whereas the county attorney has reviewed the attached and is in agreement with it, now therefore be it resolved by the County Commission of Hawkins County, Tennessee, that County Mayor Mark DeWitt is authorized to execute the attached contract and any other necessary documents to participate in the litigation as detailed in the attached. Mr. Chairman, I so move.
Motion from Commissioner Gillum, second from Commissioner Alvis. Commissioner Gillum, go right ahead.
Yeah, I wanted to share a few things with the Commission. First of all, to be clear, I did say at the Budget Committee this past week that I would be pulling this from consideration, and that was after our county attorney had advised potentially to do that, and I decided to follow his advice that day. However, as I thought about this and did some more of my own research, I really wanted to introduce this and at least share some comments regarding some of Mr. Sandlin's comments at our budget meeting just last week. Mr. Palmer beat me to the punch on the first one where he told us, Mr. Sandlin told us that you could have Holston TV no matter who your internet provider was. According to their own customer agreement, that is not true. I'll read it again for you just in case you didn't hear it when Mr. Palmer said it. This is in the user agreement. It says, I also understand that monthly subscription of internet service from HolstonConnect is required to obtain subscription to Holston TV. I must maintain the subscription to HolstonConnect's internet service throughout duration of subscription to Holston TV. So what Mr. Sandlin shared with the Budget Committee was absolutely not true according to the customer agreement written by HolstonConnect themselves. I also would like to point out concerning him saying that it is exactly like Hulu, YouTube TV, and other providers. As a user of Hulu myself, I subscribe to Hulu Live, and I get on Saturday, actually I wasn't home, so I picked up my phone and I watched the Tennessee game from my phone on Hulu Live. Had I been a Holston TV customer, I would have been highly disappointed because according to their own channel guide, only a very few number of channels are available unless you are home and connected to their HolstonConnect internet service. So it is nothing like Hulu Live that I subscribe as a user of it every single day. And then he made some claims that cable companies are not paying property taxes on fiber and on their cables. According to this document from the local government revenue, it's from, I'll pass it around if you want to know. I'll tell you exactly where it's from, but they absolutely do have to pay property taxes. Charter is paying property taxes and the franchise fee. That was an inaccurate statement to the committee that day. Satellite television providers are also required to pay property taxes, and both are doing so, and Charter is doing so, and they are also paying the franchise fee. And so I'll say this, my feelings on this, I think the reason this is so difficult for all of us, if we would all be honest, is because it's so close to home. I have very good friends who work at Holston Electric. I have family who retired from Holston Electric. I know several of the board members. I know all these folks, and it's hard for us. I think if we were talking about suing charter, we would vote on this in a second, and we'd vote to do it. But it's because it's close to home. And if we're not going to pursue this, basically what it comes down to, there's a disagreement between Holston Electric and Hawkins County. There's a disagreement. All we're doing is saying, let a judge decide who's right. That's what we're saying. But we're afraid to do that because it's people that we know who work there, and we feel bad for it, and this and that and the other. And I'll tell you, if that's not the good old boy system, I don't know what is. And if we're not willing to enforce the law equally and let a judge decide who is right and who is wrong, because I am not qualified to sit here and talk about, what is and is not a streaming service versus a cable service, but there's enough evidence here for me, and enough misstatements have been made to me about this to draw the conclusion that a judge needs to hear it. And so that's why I chose to go ahead and introduce this tonight, and I would encourage all of my fellow commissioners to apply the law equally and without consideration of anything else. What is the law? There's a disagreement about it. Let the judge decide, and we can take it from there. Thank you, Mr. Chairman. That's all I have.
Commissioner Roach.
So, Mr. Chairman, I do want to mention a couple of things that Commissioner Gillum said. He did agree to pull it, and while it's not binding, any committee that we have is only a recommending committee. And I understand that, and I respect his right to run the resolution tonight because it has his name on it. He can certainly do that. But typically, if we pull a resolution in committee and we don't vote on it and discuss it in committee, then we do pull it in the full commission. Secondly, this lawsuit is not going to be litigated or settled anytime soon. Our county attorney asked us to hold off because there's a lot more information to collect. Most of Commissioner Gillum's points that he made, I agree with. I think we do need to apply the law equally, no matter who you are. If you owe the county money because of what is written in Tennessee Code Annotated, I believe that you should pay that. And if you don't pay that, I believe you should be held to account for that. However, there's a whole lot more that we still need to, I feel like, learn. Secondly, there's a lot more time before this thing's going to be settled and litigated. And it's not the county commission's job to litigate this lawsuit. Really what our job is to decide whether or not we're going to join the lawsuit itself. We can't decide whether HolstonConnects is correct, or we can't decide whether other municipalities as represented by the Terry Law Firm are correct. That's not our job. Our job is to join the lawsuit if we feel that we should, based on knowledge we have gleaned. And I don't know that I, once again, disagree with all that. I just think that we need to hold off just a little while based on our county attorney's advice. I may vote for it later. I may vote to join the lawsuit because, to be fair, if we join the lawsuit and we lose, we're out nothing. We lose nothing. If we join the lawsuit and we prevail, we stand to collect money that we did not get in the past. However, we're a long way from that right now. And lastly, and I'll go ahead and say this since we're debating it tonight, the fact is if we join the lawsuit, we also commit ourselves to paying, I believe, 25% of the proceeds to the law firm that's representing us in this case. But in what I think, and I'm not an attorney, but what I think is if the suing parties prevail in this case and Holston Electric is found liable for those fees, then it seems that we're still going to have to receive those fees because we're still going to be applied to that fee structure as determined by the court if they decide that HolstonConnects needs to pay the franchise fee. But I don't know that. I need to learn some more. So with that said, Mr. Chairman, I'm going to vote against it tonight. That doesn't mean I'm going to vote against it forever. If it comes back up and I gain more information, I may vote in favor. But because it was pulled based on our county attorney's advice, I do believe that we need to vote against it tonight.
Commissioner Barrett, hold on just 1 second. Mr. Powell.
Just a point to clarify perhaps what's a misunderstanding. We're talking about joining the lawsuit. That's not what is at issue. We are already in the lawsuit. The county is. All right? The county has made an appearance in the lawsuit. The question tonight is whether you want to retain Terry and Company at this time to take the representation of the county. So it's not a matter of, are we going to join the suit or not join the suit? We're already there. It's simply a matter of, are we going to, at this point in time, engage the services of Terry and Company on a contingency fee basis of 25% plus the pro rata distribution of expenses. This lawsuit is going to go forward regardless of what we do, and what Commissioner Rogers said is, I believe, true. When the final determination is made, we're still going to be in the same position, all right? But we are in the suit. This is not a discussion whether to join the suit and enforce the law equally or not. We're already there. Tonight's resolution is strictly to decide whether at this point in time, the commission wishes to retain Terry and Company.
Thank you for clarifying, I appreciate it.
Commissioner Barrett.
I'm good, Mr. Chairman. Thanks,
All
Mr.
right.
Chairman.
Hold on just a second. Commissioner Gillum? I'm sorry, Commissioner Palmer. Sorry, go ahead.
Mr. Calp, so basically, you answered the question I was going to ask you. So if we're already in the lawsuit, so if we do not if we do not agree to have Terry Law Firm represent us, we either collect the money or we don't either way now already, correct?
I missed the point. If we don't hire Terry Law Firm, we what?
If we don't hire Terry Law Firm to represent us, then if the lawsuit settles against HolstonConnects, then we'd collect the money already, correct?
Then, if the thing were to settle, if you were not to retain the Terry and Company, and the suit were to be settled, then you would have 100% of your award. If it would be settled after the retained contingency agreement, the thing says I reviewed it, there's nothing wrong with this contingency agreement. It's just a question of the timing of the entry into it, in my opinion. And there's certainly valid other different opinions. But we will be in the lawsuit either way, and for good or bad, we'll abide by the outcome.
Thank you.
Commissioner Gillum.
So we are named as a party in the lawsuit, but if a judgment is made and we aren't, I guess I'm confused as to what you're saying. Because what you're saying is we don't have to join at all, and if they win, if Bulls Gap wins, we get the money anyway. Mr. Dillon, can you speak to that, please, since this is your contract?
So on that topic, we represent Bulls Gap, but we're not going to do all the work for Hawkins County and then expect not to be paid anything. There's something called the common fund doctrine. You know, the commission were to say, well, you just go ahead, you all do all the work, and then at the end of all this, we're going to collect the money, then the chancellor would have the discretion to order Hawkins County to pay, and since they're the largest shareholder, it could ultimately be a lot more than 25%. But that is in the discretion of the chancellor, but that's the answer to your question.
Okay. Thank you. Do you have any, also Dylan, do you have any facts at this time to claim that there's only 1,900 people inside the county currently using Holston TV?
Well, until there's discovery done, if it's counted upon HolstonConnect, we cannot know the answer to that. They've already made a lot of misrepresentations to this commission. Number one, you can buy a Holston TV and watch it even if you have charter internet. That's not true. We pay property taxes and cable companies don't. That's not true. So, you know, it's possible that they have 1,900 customers, but even if they do, you can't just go off how much they make monthly off from the customers. Part of the equation is also advertising revenue, which, again, because we don't have any discovery for how much advertising revenue comes to from customers of Hawkins County specifically, can't say how much that is. But charter pays the county $120,000 a year. Charter is not available in most of Hawkins County. So that should give you a pretty good idea of how much we're looking at money-wise.
Thank you. Anybody else questions for?
I have one other comment, or not for Dylan, but I just did. Anybody else have questions for Dylan?
We can't fix that from up here. We don't know what it is. So if we turn the whole system off, then it's also going to be hard to hear. So reboot. We need a reboot. Turn it back on. Test. Okay. All right. Reboot always works.
Figured out there, because earlier we could hear that static earlier.
Any other questions for Dylan? Okay.
In our last meeting, you all gave us figures of how much stuff is happening. One was $11 million. Slow it all down. $11 million. I don't see how they're making $11 million if they only have 13 customers.
Well, so I believe what Mr. Chairman said at the subcommittee about 15,000 broadband customers. Broadband means internet, phone, TV. The claim was that there's only 1,900 of those 14,000 that are TV. What are those for? But the $11 million or some dollars and change from 2021, which has grown significantly, was from all broadband. Absolutely. The commission votes to hire, we'll have that.
I'm sorry, you can send it up. Okay. Commissioner Palmer.
Dylan, in the previous meeting, there's been all kinds of numbers thrown around. We were told upward of 7 figures. I guess it kind of piggybacks off what Ms. Trent was saying. So just doing the rough math, if you take, at the high mark, the most expensive package is $119.95. Out of $1,900, you're looking at $227,000. You take 25% off, you're all. So the county would look at the high mark of $107,928.75 for 1 year. Now we know at the very beginning they didn't have 900 customers.
I don't know that. That's what they represent. The way we view that figure, they've got 30,000 plus electric customers. We figured a conservative estimate of that was that 8,000 of those approximation have that service. That may be wrong or it may be right, but we said at the time that is an approximation. Again, that number cannot be known with certainty until they're forced to swear under oath and give us discovery responses.
So we're being asked to make a decision based on numbers. Nobody knows.
It can't be known until the litigation proceeds.
So if it does go to the Tennessee Supreme Court, which Mr. Boyd indicated that it can possibly go to anyway,
those numbers will be known 30 days from now, because we'll be able to send what's called interrogatories and requests for production. They have a duty under the rules of civil procedure to respond to that within 30 days under oath. So we will know way before we go to the Supreme Court.
man, to go back on the fact that Mr. Scout said this resolution is basically to hire your own service.
Yes.
So if we're already a party into this, whether we agree to this or not, and just to reiterate, you said that it'd be up to the chancellor's decision if the county would have to pay you guys or not. So we're not, and I don't know law. By trade, I'm not a lawyer. So really, if we're not agreeing to hire you, would the chancellor still require us to pay you even though we've not accepted your contract?
That's what the ask under the contract. Now, I will say that we're representing Bill Gant at a very small state. Hawkins County's got a huge state, the biggest by far. And if you all decide to we're going to set back, see what happens, and that it would just become Mr. Calculator at that point. He wants to press on with the lawsuit if he can, but we're not going to do all the work for the county and then just not expect to pay.
So if we're already a party, so this goes
You're
back.
not, well, let me clarify that. Whenever you ask for a declaratory judgment action, you have to name anyone who's interested, that the judgment that you're asking for could affect that person. So you're a party in the sense that you are named as a respondent so that you know, hey, this lawsuit's going on. But there's been no claim filed by Hawkins County against Holston. So there's been no request for a judgment, a judge to say, hey, judge, you owe Hawkins County you got to pay it for X number of $110,000. There's been no request for any kind of judgment by Hawkins.
So would a judge not say, if they would just say, if the judge rules that yes, HolstonConnects, you need to pay your fee, would the judge not also say, hey, you got to back pay HolstonConnects?
Not if that request isn't made. You have to make a request for a judgment. As it stands, if we went to trial and won, the only ones that have made a claim were Hamlin County, the city of Morristown, and Bulls Gap, in the town of Rogersville. So if the judgment was given after a trial and there's been no cross claim by any of the parties, that would be the judgment after. Is my understanding.
Well, Mr. Chair's right. You tell me one file and the cross claim, but we go to the supervisor. We tell it off because this is all by itself. So, just like the town of Rogersville did, because we didn't responded, we would file an answer saying that we're not liable for anything because we're not a first service provider, and we'd file a cross claim against HolstonConnects. Right? That would be the claim of wrong. But there's plenty of time to do that. There's plenty of time, in my opinion, and I don't think Mr. Terry's taking to turn down the commission because we buy it over a month from now and say, hey, we looked at it and we'd like to have it represented. So, although he's technically correct as far as the pleadings already filed, we are a party to the suit because we remain in the suit. The only thing we haven't done is invest any time and effort in the following answer, which is simply saying we deny reliable. Because obviously not liable rules we have for providing a service, a streaming service. And then follow up with a cross claim, which is what you file something against the same party side of the suit that you're on. That's what the town of Rogersville would be a pro forma type of response that the Hawkins County. I've held off on that until we decided, number one, is there anything to go forward? Because we originally thought this was going to be very contentious. There were figures thrown out about this is a 7-figure. Well, that's $1 million. I don't think we're talking anywhere near that. So it just seems like we need more information, my opinion, we need more information, and then we can decide what to do. I have nothing at all against having Terry Walker represent the county. I'm quite confident in their abilities. It's simply a matter of the commission decide when they want that representative to start. Because when it does, you then have the contract of the 2%.
I can just respond to one thing. There has been no settlement talk to me. The only thing that came up about this was Kevin Keaton. Mr. Boyd approached Kevin Keaton and said, hey, HolstonConnects might want to mediate this thing, and that was 45 days ago. Nothing's been said since then. And then last week, Mr. Sandlin comes and says, we don't know you franchise fees. We pay you some property taxes, so be happy. It's kind of how that went. So there's no willingness at this point to settle. I was going to make it clear, I've been in touch with all the other attorneys. Nobody's been approached about settlement.
Mr. Rhodes.
Sorry. So a couple of things. One, there's been no indication to the commissioners here today, there's been no indication by Mr. Sandlin at our budget committee last week or by their attorney here, Mr. Boyd, tonight, that they intend to settle. And so I'm not sure if there's something being said behind closed doors that is different from what they're saying publicly, but basically there's under my opinion is that there has not been any indication that they want to have a serious conversation about settling. They have tried to downplay it and say there's only 1,900 people, and if that's the case, then they shouldn't be too worried because it won't cost them very much money, if that's the case. But it's been misrepresented to us several of these things. As I said, that the general manager misrepresented several things to us last week. And to the point of Mr. Roach's point, who I have great respect for about me pulling this, me deciding to pull that at the committee meeting and changing my mind tonight would be no different in me voting against it had we introduced it that day and then deciding to vote for it today, in my opinion. It's a matter of, we heard Mr. Sandlin out, he's given ample time to share his points of view. We were kind of out of the blue advised not to engage in conversation and not to engage in, because we were potentially in litigation or in settlement talks with these folks. And so by default, I was like, well, shoot, I didn't know that this was even going to happen, right? So I said, well, I guess we'll just pull it. And then and that's no offense to you, Mr. Cal, I don't want you to take that towards you. Once I got out of the meeting, I thought, well, shoot, I think I really would like this to be considered. And I believe all the members of the Budget Committee are here, and they could hear it the same with all commissioners here, the same as they could with just 7 of us. So I would ask you not to, in my opinion, not to put a lot of weight in that. Because truthfully, there's just 14 of us, whether it's 7 budget period or all 14 of us all together, just vote your conscience on it. If you're for it, you're for it. If you're against it, you're against it. We'll all be friends at the end of the day, but let's just vote on it. Do that.
Thank you. And I respect Mr. Gillum. We have to do this for a reason. If we're going around with resolutions and just put them before the commission, we just don't have to meet anybody. Secondly, I do want to point out, I've got a question for you. Is there another hearing scheduled anytime soon?
There's a pending motion to dismiss that the judge grants it and the case is over with. Now, that hasn't been scheduled yet, but it's ready to be scheduled. So at this point, it's sort of been, we're waiting for the largest stakeholder, Hawkins County, who's got the most skin in the game, to make a decision about whether or not they're going to participate.
So, Mike, if we do nothing tonight, so that it's, let's say that we table this motion and hold off until next month so we can collect some more information, what are the chances that that hearing is going to happen in the next 45 days?
Well, largely that's up to Mr. Boyd when he's scheduled it. In terms of what information you need to gather, I'm an open book if you got any questions.
And I appreciate that. I guess I'm going off of what our county attorney, who we voted for and hired to represent us, has advised us to do. So I'm going to try to trust his opinion since we put him in that position. And he's asked that we hold off for a little while. Do you think the meeting's going to be held within the next 30 days?
I have no reason to think that unless he filed the motion. It's largely out of my control whether or not a motion to dismiss is heard within the next 30 days.
Mr. Chairman, I move the table until the next committee, or the next scheduled commission meeting in October.
Go ahead, Dave.
Well, one, I would say that the rumors of settlement, I've heard the exact opposite. I've heard the whole thing basically been from cocky. They're basically pumping monkeys. And they're, at the end of the day, like, we're not going to pay the fee. We know that we don't have to. We're going to get away with it. That's been said by many people. But I would say it's interesting that, your point, Mr. Is it true?
Yeah.
You were saying basically Hawkins County's already a party in the lawsuit, but we don't have any representation. We don't have anybody pushing forward to the judge saying that this money is in. I understand what you're saying, but we'll wait till it's all over and then we'll file a motion for them to get the money to us. Essentially, is what you're saying. But we're not going to. What benefit would we have? What do we have to lose to enter the lawsuit, let a judge decide, and have representation from the very beginning? It's not even, to be honest, if we were to hesitate and not join the lawsuit, what we would be doing would be showing favor to a giant entity of Hawkins County who's already got a lot of power. And it's like, we have absolutely nothing to lose. It's not a personal thing. Josh highlighted that very well. I don't know what more information we need to collect. It's a matter of principle. If it's $1,900 or $19,000, if they agree to pay a fee, they're not doing that. The authority of Hawkins County is not being respected, and it sets a terrible precedent. We have nothing to lose. So why would you suggest that we wait 30 more days? What more information is there?
One is your statement that we're not represented is false. When we were served with the papers, I filed a notice of representation, a notice of appearance with the court. Hawkins County is represented in this suit. They're represented by myself on behalf of the county. The reason that I'm suggesting that it may be better to wait and gather more information about possible outcomes and the duration is because you're talking about a contingency fee that may or may not, and I see no harm. I see no harm that I can think of, because this is not going to happen next 30 days, next 60 days. And I can file an answer and a cross-claim tomorrow if that's what we decide to do. But I see no harm in waiting. I see a possible downside if it does have something happen where it settles. You've now given away 25% of your settlement, plus a significant part of the expenses of your settlement. That doesn't seem like it's right to take that risk. If you can simply say, I'm going to hold off and decide. Again, it's nothing against Terry's law firm, Terry Law Firm. They are competent and capable of handling it. It's just my suggestion to the commission, simply wait till you see additional information. The information I'm seeking is whether there's anything coming from HolstonConnects side. I think certainly Mr. Boyd's gotten an earful tonight. Perhaps there's some room for discussion.
Mr. Chairman, I call for question on Commissioner Roach's motion.
Okay, let's go ahead. Dane's had his hand up.
Object.
I understand.
Object also.
Object to what?
Object to the call for question.
Okay.
Yeah. So, if I understand correctly,
Yeah, we need to vote on the objection, Mr. Chairman, before he speaks. No offense.
Okay, so you've confused me now. Are we voting on? No.
He called for question to vote on his motion, and I
Okay.
objected to the call for question.
Okay. So we need to vote on his.
We got to vote on the
Who
objection.
did the call for question?
whether you're postponing or not.
Robbie.
Robbie.
Okay,
Here.
thank you.
Question is the
We haven't voted on the motion.
So this is yes.
We're not going to.
Debating, now we've talked debating. Correct. And then we go to the motion.
Does the call for question have to be second?
It was. No.
No.
Doesn't.
No. We're doing a call for question. We need to vote on that.
We need to vote on call for questions.
No, vote on the objection.
Objection, not the question.
If the commission be open to it, I do have a couple other points I could make before you vote on this that I was hoping to make before this got to the point.
It would have been a tremendous amount of help if GM had been sitting in the audience tonight to say that.
Sure.
That shows you what kind of care.
I agree.
Mr. Chairman, before we vote, can you vote what a yes vote means and what a no vote means?
Whenever they get it rigged up here, I'll let you know.
Can I make one remark about, there was a mention earlier, there's lawsuits going on other places.
Go ahead while they do this.
So there was a lawsuit going on against streaming services that did go to the Tennessee Supreme Court in 2022. It's titled City of Knoxville versus Netflix. The Tennessee Supreme Court says if you're a streaming service, which I'm not going to get into all the technical aspects of that, but if you're an over-the-top OTT streamer, then you don't have to pay franchise fees. Now, what that means as a practical matter is if you're providing TV service and you also own or operate lines in the public right-of-way, you've got to pay the franchise fee. Netflix does not operate any lines in the public right-of-way. Holston Electric does. It's the same business model that AT&T Uverse used to use. Where they ran the fiber lines for telephone and then provided internet through that same fiber line. It's exactly what Holston Electric did. And in that Tennessee Supreme Court opinion, it says, plain as day, that if you own the lines, for example, like AT&T, you have to pay the franchise fee. So there's no other litigation anywhere else in the state that we're just waiting on the outcome from the Tennessee Supreme Court. That's been resolved and answered.
We need a second on the call, on the objection.
I did
Danny.
Thank you.
2 times.
Okay. So a yes vote on this means
that he objects to the call for question. A no vote means it goes back to call for question.
So yes vote allows debate to continue, a no vote causes debate to end.
Yes.
On the motion to table.
On the motion to table.
Yes. Everybody clear on that?
Yes.
Clear as mud.
Yes, yes.
Keep talking.
Yes means you keep talking, no means you stop talking.
Yes.
Go ahead and vote.
I'm gonna vote against 5 o'clock.
10 yes, 4 no.
Okay, so we continue discussion, Dane.
I have a question for you, sir. So, if I understand correctly, they were talking about how there was possibly, this would be dismissed in the near future. Would it not be strategically intelligent for Holston to apply pressure to the commission to say back off, and then when it goes to the court and there's less people in the lawsuit who are making the claim, particularly the largest portion of the lawsuit, the most applicable amount, with Hawkins County having the most claims to, would it not be more likely that a judge would look to dismiss it? Would that have any effect on that?
Well, I don't think the judge is going to look at the number of parties and be swayed by that, but it is important that Hawkins County is represented at that hearing.
So it's not the way I would think it.
Yeah, it's just not how many people have thought a lawsuit is going to affect my decision.
Commissioner Gillum.
Not too many years ago, before I was on the commission, we might have voted on 1 or 2 of these since I've been on here. I can't recall exactly. We've been given the opportunity to join in lawsuits against large drug companies. And never then did I hear anybody saying, you know what, let's put it off and see what happens, and we'll file a motion later to hopefully get the money after the judge makes a decision. And the reason is because that was an entity that we have nothing to do with. These folks are our friends and neighbors, and we don't want to do it because we're afraid it's going to make us look bad because of who Holston Electric is. Let's just say what it is. That's what it comes down to. That we feel like there's a lot of people that have influence that work there, a lot of our friends work there, a lot of people like that work down there, and we want to put it off and kick the can down the road and maybe try to do something different and this and that until everybody forgets about it. And I understand it. I mean, it ain't my favorite thing to talk about neither. But again, if you want to do it, vote for it. If you don't, vote against it. But there ain't no sense. We ain't going to know any more 30 days from now than we do tonight. And that's the truth.
And they're not going to settle. They're going to randomly just start talking about settling here. They've had 2 months to do it.
Well, since April, actually.
Mr. Boyd.
I don't want to jump in on his part of the argument.
That's all right. We'll just have court right here.
The whole issue is, until there's a decision by the Tennessee Supreme Court that this is a streaming service or a video service, then, that's got to be decided, because if they decide it's a streaming service, there's not going to be a franchise thing. So that's the only thing I would argue about why it's a little bit premature to be acting and voting on this at this point, because it's not an issue of money. It's an issue of the decision that's got to be addressed somewhere down the road by other counties who, one of which is going to appeal to the Supreme Court and have that issue decided. That's the issue. It's not how many people have joined in and how many people not, or where it is on argument for the chancellor or whoever is going to end up hearing it. I'm just saying the issue is, if it's decided that there's a streaming service, there's no franchise tag. Let me say one other thing. Not a single one of the counties involved in this thing has ever passed an ordinance or a resolution joining in this thing to determine whether or not they want to claim that this was a streaming service. Nobody has ever done that. That's going to be another issue somewhere down the road. I'm just saying, you're a little bit premature on this. And I appreciate the opportunity to be heard again, because I don't want to, edge into his time, because he had an opportunity to speak, and so did I.
Commissioner Barker.
I guess I'm a little confused. I think when you first talked to us, you said there was an affidavit that he took to the state that he signed and agreed
And
to
that's the
pay
point I was just about to bring up in response.
the franchise fee.
Yes.
So if he wouldn't, if Holston Electric wasn't required to sign a franchise fee, why would he have went to the state and done that? And why, and I'm sure the cost of that's been built in over since 2017?
Well, they started building the lines around that time, but I think
Yeah.
the service began late 2018, early 2019. But
2020.
2020.
I looked at
So-
the paper earlier today that there were some parts in Rogersville in 2019.
So if there was, I mean, once again, if there's an affidavit signed, evidently somebody thought it was a necessity.
Yes.
And he bypassed the county commission to do that and went straight to the state. Is that correct?
That is absolutely correct. And there's one issue in the lawsuit. Are they a video service provider or not? We've got an affidavit from Jimmy Sandlin that says we're asking the TPUC, the Tennessee Public Utility Commission, to give us a franchise because we want to sell video services. And that was an affidavit. And the reason they did that is because you cannot sell TV in Tennessee until you either come through the commission or you go through TPUC. Or there's enforcement mechanisms from the state where they come and shut you down. But there is not an enforcement mechanism for payment of the franchise fees. So they did step one, got permission from the state to sell it, but then they didn't follow through with what they were supposed to do, which is pay the counties and municipalities, which they operate, I guess thinking that no one would notice.
No resolution, no ordinance was ever adopted. That's
So-
pure and simple fact.
If I could address that. So prior to 2008, if you wanted to sell TV service, you had to come to a county commission and negotiate the rate you were going to pay them. In 2008, they passed a law called the Competitive Cable and Video Services Act, and that's what this whole lawsuit is about. The provision that Mr. Boyd is talking about says if you're an incumbent service provider, which means you are providing cable, TV, video, whatever, before 2008, the county commission's got to pass a resolution one way or the other saying we want them to pay 5%, that the state sets that rate, or we'll stick with the rate that we already negotiated with them directly under the local franchise. It's a non-issue. That's the least of the lawsuit. The only one question in this lawsuit is are they a video service provider or not? And again, we have an affidavit from Jimmy Sandlin saying that they are.
Mr. Travis.
My question's been answered, Mayor. Thank you.
Mr. Thacker.
Call the question.
All right.
Are we on the motion to table now?
Yes. We are on the motion to postpone, not table.
Yes, that's correct. Thank you for correcting me. It's a motion to postpone until the
Motion to
October.
postpone. Table will be taken up again at
I've
this
made
meeting.
that. I messed up anything. Motion to postpone, that's correct. It's not tabled.
Okay, so we've got a motion on the floor to postpone voting on this resolution until, did you mention the date?
The next scheduled commission meeting in October.
Next scheduled commission meeting in October. You got that? Getting it. We're working the ladies to death tonight.
Be the 28th.
On the 28th of October.
Yep.
Let me know when you're ready to vote. I must, Mr. Boyd and Mr. Parker, I appreciate you both coming tonight. This has been probably one of the most interesting discussions we've had as a commission. I mean, it's been long, but at least we're trying to learn something. Anybody on the commission who went to the concert in Knoxville last night and got home at 3 o'clock in the morning needs to go to bed. Are we ready?
Yes, sir, we are ready.
Okay. We understand what we're voting on.
Postpone until postpone.
Motion to postpone. Go ahead and vote.
Four yes, 8 no, 2 abstain.
Okay, so that motion fails. We're back to the motion as presented on the resolution. Does anybody have any further discussion? Are you all ready to vote on 2024-0907?
Hang on just a minute.
Okay, we're hanging.
All right, we got it.
Okay, go ahead and vote.
10 yes, 3 no, 1 abstain.
Okay, motion carries. Thank you all for the discussion. Really, I appreciate it.